Can adult protective services be held liable for their actions? Have you ever wondered about the role of adult protective services and whether they can be held accountable for their actions? Let's break this down. Adult protective services agencies are government organizations that investigate claims of abuse, neglect, and exploitation of elderly and dependent adults. Their main goal is to protect vulnerable individuals by responding to allegations and ensuring their safety. Generally, these agencies and their workers enjoy a level of legal immunity when they act in good faith while performing their duties. This immunity allows them to conduct investigations without the constant fear of lawsuits. However, this protection is not absolute, and there are situations where they can be held liable. First, let's talk about negligence or misconduct. If an adult protective services worker acts with gross negligence or intentionally ignores clear signs of abuse, they may face legal claims. For instance, if they fail to investigate a credible report of abuse and harm occurs, a lawsuit for negligence could be possible. Next, we have the violation of rights. Adult protective services must respect the rights of the individuals they serve, including the right to make their own choices. If they conduct an investigation without proper cause or breach confidentiality laws, they could be held liable for those actions. Additionally, there are statutory duties that adult protective services must follow. They are required by law to investigate certain reports, especially those involving criminal activity. If they fail to do so and someone gets hurt as a result, this could lead to liability. Civil rights claims can also come into play. If adult protective services discriminates against an individual or abuses their power in a way that violates constitutional protections, they may be held accountable under civil rights laws. It is important to note that while adult protective services workers typically have immunity for actions taken in good faith, there are limitations. Confidentiality laws protect the privacy of clients and restrict the disclosure of investigation details. Moreover, reporting laws mandate that adult protective services investigate allegations of abuse, even if the elder does not consent, especially when a crime is suspected. In the context of elder law, the involvement of adult protective services can significantly impact an elder's legal and financial matters. For example, their investigations may reveal financial exploitation that affects an elder's estate or trust. If adult protective services mishandles such cases, it can complicate estate administration or delay protective measures. Attorneys in elder law should be aware of the role and limitations of adult protective services. They can assist clients in asserting their rights during investigations or challenge actions that seem improper. Legal professionals can also collaborate with adult protective services to ensure interventions align with the elder's best interests while respecting their autonomy. In summary, while adult protective services have a duty to protect vulnerable adults and generally enjoy legal immunity for their official actions, they can be held liable if they act negligently, violate rights, or fail to fulfill mandated duties. Understanding this balance is essential, especially in elder law, where the actions of adult protective services intersect with estate and trust matters.